Hello everyone, welcome to the channel Law Today, a channel you can trust for a detailed analysis of legal and political issues. In this video, I am going to discuss in detail the provisions of the Citizenship Act of 1955, which deals with the acquisition and determination of citizenship of India after the commencement of the Constitution on 26th January 1950. In an earlier video, I have discussed the provisions of the Indian Constitution, Articles 5 to 11, which deal with the citizenship before the commencement of the Constitution. Before I commence my presentation, I request you to please subscribe to the channel and press the bell icon on the home page, which will be a huge encouragement for me to come up with some more videos on different aspects of law. The Indian Citizenship Act was enacted by the Parliament in the year 1955. The Act deals both with the acquisition and termination of citizenship. It prescribes 5 modes of acquisition of citizenship. They are by birth, by descent, by registration, by naturalization, and lastly by annexation of a territory. And the Act prescribes 3 modes of loss of citizenship. They are renunciation, termination, and determination. The first mode of acquisition of citizenship is by birth. According to Section 3 of the Act, every person born in India on or after 26 January 1950 but before 1st July 1987 is an Indian citizen, irrespective of the nationality of his parents. Section 3 was amended in 1986. Before the amendment, any person born in India after 26 January 1950 could be an Indian citizen. But the amendment of 1986 stipulates that it is no longer adequate to be born in India to be granted Indian citizenship. At the time of his birth, either one of the parents has to be an Indian citizen for the person to become a citizen of India. Section 3 was further amended in 2003 and became effective from 3rd December 2004. The amendment introduced a notion of illegal immigrant and disallowed citizenship by birth for children born in India if either of the parents is an illegal immigrant. After the amendment, every person born in India on or after 3rd December 2004 is a citizen of the country if both his parents are Indians or at least one parent is a citizen and the other is not an illegal immigrant at the time of his birth. Subsection 2 of Section 3 provides 2 exceptions to subsection 1. Thus, a person born in India after 26 January 1950 will not acquire citizenship under subsection 1 of Section 3 if his father possesses diplomatic immunity and is not an Indian citizen, or his father is an enemy alien and his birth occurs at a place under enemy occupation. The next mode of acquiring citizenship in India is by descent. Descent means citizenship through their parents. Section 4, which deals with the acquisition of citizenship by descent, provides that a person born outside India on or after 26 January 1950 but before 1992 is a citizen of India by descent if his father was a citizen of India by birth. Under this provision, If his mother was an Indian citizen, he could not become citizen by descent. Thus, this provision was discriminatory against women. Hence, this provision was amended in 1992, and gender discrimination was removed, and amendment became effective from 10th December 1992. Now, a person born outside India on or after 10th December 1992 but before 3rd December 2004 is a citizen of India if either of his parents was a citizen of India. Section 4 was again amended in 2003, which became effective from 3rd December 2004. Now, if a person is born outside India on or after 3rd December 2004 has to acquire citizenship, his parents have to declare that the minor does not hold a passport of another country and his birth is registered at an Indian consulate within 1 year of his birth. The 2003 amendment has mandated the central government to create and maintain a national register of citizens and to issue national identity cards to all the registered citizens. A newly introduced subsection 1A provides that a minor who is a citizen of India by virtue of section 4 and is also a citizen of any other country shall cease to be a citizen of India if he does not renounce the citizenship of or nationality of another country within 6 months of attaining full age. The next mode of acquiring citizenship is by registration. That is, Indian citizenship can also be acquired by registration. According to section 5, the central government may, on an application made in this behalf, register as a citizen of India any person not being an illegal immigrant who is not already such citizen if he belongs to any one of the following categories. The following are the categories. First, a person of Indian origin who is ordinarily resident in India for 7 years before making an application, or a person of Indian origin who is ordinarily resident in any country or place outside undivided India. Next, a person who is married to a citizen of India and ordinarily resident in India for 7 years before making such application. The next category of persons are minor children of persons who are Indian citizens. Next, a person of full age and capacity whose parents are registered as citizens of India under section 61A. Next, a person of full age and capacity who or either of his parents was earlier citizen of India and is ordinarily resident in India for 12 months before making an application for registration. Lastly, a person of full age and capacity who has been registered as an overseas citizen of India card holder for 5 years and who is resident in India for 12 months before making an application for registration. Further, he must have resided in India during the 8 years immediately preceding the said period of 12 months for a period of not less than 6. The fourth mode of acquiring citizenship is by naturalization. Naturalization means admitting a foreigner to the citizenship of a country. Section 6 deals with acquisition of citizenship by naturalization. This provision provides that where an application is made by any person of full age and capacity not being an illegal immigrant for the grant of certificate of naturalization to him, the central government may grant him the certificate if he fulfills the following conditions specified in the third schedule. Let us now consider the various conditions laid down in third schedule to the Act. Firstly, that he is not a subject or citizen of any country where Indian citizens are prevented from becoming citizens by naturalization. Next, if he is a citizen of any country. Next, he has either resided in India or been in the service of Government of India throughout the period of 12 months immediately preceding the date of application. The next condition is that during the 14 years immediately preceding the said period of 12 months, he has either resided in India or been in the service of Government of India for periods amounting in the aggregate not less than 11 years. There is a proviso to this provision which provides that for the person belonging to Hindu, Sikh, Buddhist, Jain, Parsi or Christian community in Afghanistan, Bangladesh or Pakistan, the aggregate period of residence or service in the Government of India shall be not less than 5 years and not 11 years. This proviso was added to the Act in 2019. Next condition is that he is of good character. Next, that he has an adequate knowledge of a language specified in the 8th schedule to the Constitution. The last condition is that after naturalization, he intends to reside in India or enter into service with the Government of India or under an international organization of which India is a member or under a society, company or body of persons established in India. If for any reason his application for citizenship by naturalization is refused, he must be informed the grounds and be given an opportunity to make a representation against the Next, Section 7 provides for citizenship by incorporation of a territory to India. On any territory becoming a part of India, the central government may notify the persons who shall be citizens of India by reason of their connection with that territory. Thus, people living in Pondicherry, Goa and Sikkim became Indian citizens. Now, let me draw your attention to one important aspect of citizenship that is dual citizenship. That is, overseas citizenship of India for persons of Indian origin who are actually residing outside the country. The Citizenship Act was twice amended to provide for dual citizenship. The Amendment Act of 2003 provides for acquisition of overseas citizenship of India by persons of Indian origin of 16 specified countries other than Pakistan and Bangladesh. This Act provides for the manner and methods by which a person could acquire a citizenship of India and its revocation. Then, Amendment Act of 2005 actually expanded the scope of grant of overseas citizenship of India to persons of Indian origin of all countries except Pakistan and Bangladesh. And it reduced the period of residence in India from 2 years to 1 year for persons registered as overseas citizens of India to acquire the Indian citizenship. The Act also provides as to how a citizen could lose his citizenship. There are 3 circumstances in which a citizen could lose his citizenship. Section 8 provides for renunciation of citizenship. It states that any Indian citizen of full age and capacity can renounce his citizenship by making a declaration to that effect and having it registered. While a male member renounces his citizenship, every minor child of his also loses his citizenship, but any such child may within 1 year after attaining full age by making a declaration express the desire to resume the Indian citizenship and thereupon again become a citizen of India. Next, termination of citizenship. According to Section 9, a citizen of India ceases to be so on his voluntarily acquiring citizenship of another country. This provision does not apply during a war in which India may be engaged. There is no automatic loss of Indian citizenship by acquisition of a foreign passport. Whether a person has lost his Indian citizenship or not is to be decided by a designated authority of the central government. It is only after such a decision he ceases to be an Indian citizen. Under Section 10, a citizen of India by naturalization, marriage, registration, domicile and residence may be deprived of his citizenship by an order of the central government under the following circumstances. Firstly, if the naturalization or registration was obtained by means of fraud, false representation or concealment of any material fact. Next, if he has shown disloyalty and disaffection towards the Indian Constitution, or if during a war in which India is engaged, he carries on any activity with the enemy, or if within 5 years of his registration or naturalization, he has been sentenced to imprisonment for not less than 2 years, or if he has been ordinarily resident out of India for 7 years continuously. This last provision does not apply if he is a student abroad or is in the service of Government of India or an international organization of which India is a member, or has registered annually at an Indian consulate his intention to retain his Indian citizenship. However, before making an order depriving a person of his citizenship, he must be provided adequate opportunity of a hearing. Friends, before I conclude, I would like to thank you for patiently listening to this lecture. Thank you.